All right. Hello, everyone. Let me try it again. Hello, everyone. This is Curt and welcome to another edition of Fire Law Roundup for what's today, the 17th of October. And Brad, why don't you go ahead and take us away?
Sure. Today's really interesting. I probably say this about every day because we find this stuff really interesting. And if you're watching, you probably do too. But let's do a couple of them. The one I'm going to spend some time on is the FDNY firefighter who is reinstated. We'll get to that, but I'm going to try to get to some really quicker ones first. Let's start in East Cleveland. I don't understand this for a lot of reasons, but
I do. I lived it. So I can...
Okay. So here's what happened. So the Ohio Court of Appeals has just upheld a 1.6, and this won't be the end of it, $1.6 million verdict. There will be more with attorney's fees, et cetera, because the city violated the minimum staffing requirements in the CBA. I don't need to say much more than that other than, look, back in 2016, they reduced it. They lost. They went through hearings and appeals and arbitrations, and there were some temporary reversals, some hiccups, but they corrected it with another arbitrator and another hearing. In any event, after 6 years, the city has now been ordered to pay back pay and or damages, et cetera, for non-compliance. I mean, fines and penalties. What is really interesting, all because they reduced the staffing below the bargained and agreed to amount in the CBA. So I won't get too much more into this, except there are some really interesting things. First, in Ohio, apparently you can fine and award punitive damages against the city. You can't do that in a lot of states. A lot of states are immune from penalty type damages and fines. So this was really interesting that a court would award that. Nonetheless, they were fined like $750 a day for a lot of days of non-compliance.
But Brad, this was contempt of court. This wasn't a fine issued by the arbitrator or the state labor board. This was a fine issued by the court. The court ordered them to increase staffing, and the city went, and the judge said, "Oh yeah, $750 a day for not complying with my order." And then they still didn't comply. They went like this, and now it's $1,250 a day.
Right.
So we're talking about contempt of court there. And now there may also be, as you suggest, there may also be some additional damages related to the lack of staffing on those days that, typically in a collective bargaining environment, if you're supposed to pay two people extra a shift, the typical arbitrator's award on top of this is going to be, you got to pay the union that amount there. Right. Because now they were supposed to have 10. Now you only had 8 people doing what 10 should have. So the people who were working should get some, their workload went up. And so I said that I lived this. I've seen municipalities do this throughout my career. And it's gambling with other people's money. And I got into this a little bit in the blog, but when you own your own business, if you make a decision and it costs the business money, it comes out of your pocket. Well, that's a big boy decision that you make as the owner of the business. But what happens when you don't own the business? You're gambling with other people's money, right? And so you're rolling the dice. And in this case, with a revolving door of elected officials, you have somebody who's the mayor or the city council, whoever is running the show in this particular community. They make a decision in 2016 saying, I'm not going to be around by the time this thing is. We'll just have our lawyers fight it and appeal and stretch it out. I'll be governor by the time this thing is heard. So who cares? No, seriously. And
it's a great.
And it's not right. And I get into a discussion with somebody about this, saying, well, why should the taxpayers be responsible for this? Why? Because if they're not held accountable for breaching a very clear agreement, they or someone else are going to do it again.
Yeah.
Because there's no consequences to it.
And so that's the problem. That's the problem with holding municipalities in contempt or fining them or punitive damages, why a lot of courts won't do it, saying we're not going to burden the taxpayers. But if you're not, in my opinion, if you're not going to do that, then fine, you pay it.
Yeah, the bottom line is if you don't hold them accountable, they're going to do it again, and they're going to keep doing it, and they're going to ignore court orders. They're going to ignore collective bargaining agreements. You're going to have labor strife. I guarantee you 1.6 million, that seems like a lot, and it is a lot. The labor discord that's created by this kind of nonsense in terms of firefighters stretching out injuries, going off injured for things that when people are happy and productive and feeling like they're valued, they don't go off injured. They just suck it up. All of the additional costs dwarf that 1.6 million. And those are all hidden. Those are all hidden. They're hidden in workers' comp. They're hidden in overtime. They're hidden in a lot of different things. Okay. Right. In grievances, in other lawsuits. So you can't calculate the harm that this kind of nonsense causes within an organization. And I say that from experience.
I guess where I started is, how are you going to win? You have an agreement. I'm presuming the agreement was pretty straightforward. From what I read, there weren't too many ways to interpret the staffing level, and the city admitted we're reducing it. What are you debating? I want to know from the city, what were you thinking when you blatantly violated CBA?
They're thinking we're going to fight it and we're going to make them drag this out, and maybe our economic woes will be over in a few years, or I won't be here, somebody else will be here, and it'll be their problem, but I'll get through this year.
Yeah.
And again, you can't do that when you own the business. You can't do that because you're going to have to pay the piper.
Right.
In municipalities, they don't. And I think maybe personally, and I put this in the blog, maybe it's time to hold elected officials personally responsible, almost like a fiduciary of a corporation, where if you're a fiduciary and you pull a stunt like this, you're a CEO of Coca-Cola, or you're on the board of directors, and you're involved in this kind of nonsense, and then you leave the board, you could be personally liable for breaching your fiduciary duties.
Should be.
So, that might be an alternative here. But I've lived this. I've represented unions in this situation. I know the lawyers on the other side, and I know the kind of antics that they pull to drag it out, and meanwhile increase their own fees while they're dragging it out. And it's just, and who pays? The taxpayer pays. And
you've got no good faith basis. Hence, again, punitives, fines, etc. So, okay, we won't go on, but I think if Curt and I could cast stones at the other attorneys for doing, violating the CBA on a question of interpretation is one thing. There was no interpretation.
That's one thing, right? Absolutely. And by the way, something I didn't put in the blog, this city apparently pulled the same stunt in 2009 when they went from 12 down to 10. There was a big several lawsuits and grievances and everything when they went from 12 to 10. Now they went from 10 to 8. Maybe if the courts had held the city responsible back in 2009, maybe the same cast of characters might not have said, hey, let's do that again to save a little bit more money.
And hopefully what you don't see here is retaliation against the union saying, well, I guess we don't have any more training money. So, because you sued, we have no more training money, which would be another cause of action, another suit, right? Retaliating for enforcing rights. But
no doubt elected officials will be pointing the finger back at the union saying, they're why we're in such that this is why we don't have money for school books. This is why we don't have money for this or that. And not really, saying, yeah, we own this one. We screwed this up.
Okay, let's do an easy one. U.S. Forest Service has been sued over its retardant use. This is a tough issue because wildland fires are going higher, and there's only so many ways to fight a wildland fire. The most effective, obviously, with the plane dumping all the retardants. And they've been, as you noted, they've been filing these suits for decades against the Forest Service. They claim they represent thousands of concerned citizens, present, former, retired service employees. They're claiming that they're violating the Clean Waters Act. As far as I'm concerned, this should be dismissed unless the industry has known to have a better fire retardant that doesn't, and I'm assuming there's some proof that it does actually damage the environment. I thought these did not. I thought this a long time ago, they had cleared this as being environmentally insensitive. So maybe you know.
I still consider myself to be a structural firefighter. I occasionally go to wildland fires here in Exeter, but my knowledge of the retardants that they're using, my understanding, we use Class A foam, and we occasionally will use it on wildland, but my understanding is, like you suggested, it's not toxic, but I don't know if the product that they're using actually is. So it'll be up to the courts to figure all the science of that out.
Yeah, but I'm somewhere in the back of my mind, I remember seeing an EPA review of this and saying that the retardant does not cause, if the government has determined that it's non-toxic to the environment and to fish and wildlife and all that, I don't know what they can say, but in any event,
one of the points in here was that it's not that they're using this particular product, but that they're using it within certain navigable waterways, or within the boundaries of navigable waterways. So they're saying no problem using it if there's no chance it's going to get into a river, or a large body of water, but that they're not using the right decision making in terms of where it's going to get dropped. So
still, you contaminate the soil, you can contaminate the water, right? I mean, that's but I would think if you're going to say that the air pilots are, or the incident commanders are calling for a bad drop, one, this ain't precise, right? You can't control the wind. You can only drop when you can, et cetera. So this will be interesting, but this should be dismissed. In my 2 cents. Let's do one really quickly and then focus on two, because there are two that I'm really excited about that we're going to just have a field day, and I think all the fire departments should be talking to. Let's just jump to Lansing, Michigan for a second. First of all, unfortunately, University of Michigan beat Penn State, so I'm not overly happy about that. That said, Big Ten stuff aside, a Lansing firefighter has been awarded $1 million in damages for discrimination. This was allegedly reported to the city. The city allegedly didn't take serious action about it. The firefighter, who is African-American, claimed that he was being subjected to a hostile work environment and that the city failed to address it. He claims that a banana was left on his windshield. Obviously, we know the race implications of banana. There was a 5-day trial, and the city was hit for $1 million in damages. There's always a million questions in these cases for juries, and I can't get inside a jury's head ever to what they were thinking, but 5 days of proof on this, presumably, and I got to say this, what gets me, and I don't know the answer, I'm just throwing this out. I understand where fire departments may be accused of being insensitive, racist, taking discriminatory, hostile, retaliatory actions, et cetera. What surprises me more is a city like this. You would think that they would be able to say, look, we investigated, we trained, at a minimum, investigate and train, right? As everyone knows or should know, it doesn't matter what your accusation is, whether it's right or wrong, investigate or train. That way you can always say, I did the minimum, and that will help you out most times. But here, did they not do more? Like, look, if I'm faced with this and I said, well, I don't think, it was one of our firefighters, it was a neighbor who put the banana on, right? Maybe it wasn't anyone under the city's control. I'm making this up. The city at least is going to say, but we're going to make clear our policy of non-harassing, non-retaliatory, non-discriminatory intent to all our employees. We're having another training. We might even up the training. We're going to investigate this. We can't come to the conclusion, let's say, who put the banana here. And I'm presuming the banana was one of many things that he alleged, but because that wouldn't result in $1 million. One banana is not worth $1 million. But I'm surprised that the city would have been hit, because it seems like the city would have, and I don't know, take a lot more action than turning a blind eye. And $1 million makes it look like they turned a blind eye. I just have a hard time believing that most cities would turn a blind eye to something like this. But I didn't sit through 5 days of trial, so I don't know what the proof was.
Yeah, and I find it hard to believe that the city of Lansing turned a blind eye to this as well. But it comes down to proof. it comes down to, witnesses and evidence and,
Right.
the
5 days
jury-
trial.
The jury ruled what it ruled. Sometimes, right? Even in a football game, baseball game, the umpires get it wrong, but they get it right because that's when you're out, you're out.
True.
So-
Okay, now we have two great cases. And I didn't mean to any disservice to the other ones, but these are really why you should be watching this show. I never know whether we should start with this, end of these, but let's talk about two Texas firefighters. I could totally see this happening, and I'm struggling whether this is I'll give you the facts, but I'm struggling whether this is actually protected or not protected speech. My feeling is it's not, just to jump out, but let's have this debate. I love this discussion. So all that happened here is, I think the town or the municipality, I don't know who put the new police chief onto the board of what I presume is a not-for-profit contracted fire company. And I believe that there were issues, financial questions. So the municipality puts in somehow, or maybe there was an agreement, I don't know, but it looks like the municipality somehow ordered or was you couldn't do this in New York, so I don't know. It was ordered, put in the police chief as acting fire chief. Not a conflict of interest in any event. I watched the news clip that you put on. It was very, very interesting for First Amendment purposes. And if I'm the municipality, it's my exhibit A as to what was the speech involving. So they went on, two firefighters sat around a table and they voiced, I thought it was three because you see three people around the table, but at least two of them have been dismissed about them claiming that the fire chief / police chief is abusing his power, is creating a hostile environment, not based on any protected activity, just that he's a mean person, right? So this isn't a race, sex, gender issue. This is just he's being mean. And the term they use on the news is he's being short with us, and they don't like him. So to me, so they want, and I wrote this down, accountability and change. That's the quote they use. They want accountability and change. The chief said, I just want them to do their job. And he admits, I've been short with them because it's hostile back and forth. So the chief also says, listen, I'm not going to be here forever. I'm just appointed to do this until their financials are straightened out. So these two firefighters have been terminated. Right. And the question is, to me, what's coming, presumably, is a potential First Amendment suit. And that's not what's before us. You just noted they've been terminated. I would suggest in my Pickering analysis and others that this is not protected speech. I want to hear what you hear, but I see no matter of public concern. These seem like completely internal issues, certainly going to create discord in the organization, because I don't know that they represent everybody. And did everybody want them to go on TV making these comments? That puts them all in a bad light. So maybe it crosses the discord threshold where speech is not protected. So I think their termination will be upheld if they sue on First Amendment. Curt, what do you think?
I agree. I agree. And I'm going to put my hat on as a plaintiff's attorney. So they come to me, we're upset, we got fired. What can we do? We've got to consider the First Amendment. And I want to run through my Pickering analysis, but I think you and I are going to come out on that. I would not feel comfortable resting the entire case on that. So I'm probably going to be trying to find some sort of whistleblower protection. I don't know if we're going to be able to find it. Some states have a sort of generalized whistleblower, and maybe it could fit into that. I think also if these folks are some sort of a volunteer fire company, 501c3, and he is on the board of directors, we may be able to find some sort of fiduciary obligation or maybe bylaws violation that we may be able to go after on that account. So, but I think we're struggling outside the First Amendment. We're struggling there to come up with some way to get them reinstated. Now, First Amendment basic Pickering analysis starts with, is it a matter of public concern? Yeah, I think this is a matter of public concern. We'll give them that one. Okay. Did they do it as private citizens? Okay. Well, we got a problem because they were sitting in a fire station. It looked like they were in uniform. So it's kind of hard to say you did it as private citizens. But there's a bigger issue. There's a sort of a predicate issue when it comes to First Amendment, is that it's got to be government that is doing this. And if he is sitting on the board of a 501c3, there's a fair question about whether or not it's government. Now, we've got cases that go both ways. So, it's kind of hard to predict whether they're going to be considered, the fire department here is going to be considered private or public. But that's an issue that it may cause us not even to get to the Pickering if it's determined that this is a private nonprofit. So again, a lot of obstacles in the way of this. And if the chief is in fact going to be leaving in a couple of weeks, as they suggested in the video, then maybe they'll just get their job back, and that'll be the easiest thing to go on. Now, having said that, I have a lot of sympathy for the police chief because, police chiefs have authority and they're used to saying, all right, folks, this is how we're going to conduct our operations, and everybody, salutes sharply and right. And everybody follows it. Now he comes to a fire company where he doesn't really know what's going on, and maybe he thinks he does, and the folks are not happy. Are these just disgruntled firefighters? Are they raising legitimate issues? And I think it's kind of harsh, especially if he's going to be leaving shortly. I think probably a suspension, at least until he finishes his job, probably would have been more appropriate. But at any rate, a difficult, interesting case. But how about your analysis on First Amendment?
Well, I mean, I really think it may be government because the government put him in, right? So that's the link I don't know yet, because we don't really know how he got in there. I don't care that he's also the police chief, although that may be a factor in saying, well, the government chose a government employee to put in, and the police chief answers to us as police chief. So is volunteer, or who knows? I don't know who's paying him, right? But I'm betting we could probably find he's government, even that the employee's government, even the organization is not, the employee
The cases do talk about a nexus, and when you're looking at nexus, they look at funding and everything. But certainly, I think what you're suggesting now really goes to that nexus. And maybe in an ordinary case, it might not be, where somebody is, somebody who's not the police chief is serving. But I think that would certainly weigh in favor of that nexus between government.
But I don't think the speech is in any way protected. And I think ultimately they shouldn't have even been terminated. If you want to go out and express we're unhappy with the chief because he's being mean to us, boo-hoo. I hate to say it to the police chief / fire chief / whatever, but whoever made the decision to terminate these guys, grow a set. I don't know what to say. Just grow a backbone. You need to really be a little more tolerant to all politicians and elected officials know you're not going to please 100% of the people. If you're lucky, 51%. The other 49% are yelling about you on TV every day. Suck it up. I just don't know what to say to anybody why would you react like this? I'd be like, look, they have the right to, my response would be, they have the right to their opinion. Sorry, they're upset.
Yeah, I think I would have a little bit of a concern about using the station to do the interview. I think if I was advising those firefighters ahead of time, I would have said, make sure you're off duty or out of the station, out of uniform, that you're speaking as private citizens. Make that crystal clear. But
okay. So, but again, just everybody, there is no lawsuit. We just, Curt and I just obviously honed in on that's presumably what may be coming. And if it's me, I'm saying they should pass. Suck it up. Okay. I love this next case. I can't tell you how great this is because I disagree with the holding, and I think it gets reversed on appeal if they appeal it, and I assume they will, and because it links to something that happened last week and a couple weeks before that. So here, very simple facts. An FDNY firefighter, he was terminated in March. From the FDNY. He refused to get a COVID vaccine. He did it on religious grounds, right? Which we know all the federal courts have said, tough noogies, right? It doesn't matter. You have to get the vaccine. If the employer wants to fire you, they can. That's been the law. And here's part of my point. That was the law at the time. And the understanding at the time the employer made the decision to terminate him, which I totally disagree with. I do not want anyone to say that I was opposed to the mandatory vaccines. I remain opposed to mandatory vaccines and termination as a result. It's a slap in the face, but I'm here as a lawyer, not as a citizen. So as a lawyer, look, the courts all held, I disagree, but the courts all held employers have the right to terminate their employees. Now, what's happened is a court has gone back and said, based on what we know now, 8 months, 9 months later, your decision back then was incorrect because I'm going to read exactly what you quoted him saying, because this is important. He said, hindsight is a powerful tool. That's what I want to talk about now. He says, hindsight is a powerful tool. The pandemic today is not what it was a year ago or even 2 years ago. Being vaccinated does not prevent an individual from contracting or transmitting COVID-19. Guidelines regarding quarantine and isolation are the same for vaccinated and unvaccinated individuals. He said, this is not a commentary on the efficacy of the vaccination, but how we are treating our first responders, the ones who work day to day throughout the height of the pandemic. They deserve better. I agree with all of his statements. But here's my question of law. So we are going to allow someone, an employer, to be judged on their actions about what we know later. Just for those constant listeners, let's talk about last week. Last week, we had a situation where we evaluated later, months later, a decision that happened before. And so it was a medical issue, I think. And the employer said, listen, the employee said, I'm going to have an exam in 2 months. That could change things. I might be able to do my job duties, even though I'm not today. In 2 months, I might be able to.
Case, yeah.
Right. And the time had passed. They could terminate them. And we said they don't have to keep waiting 2 months. They don't have to keep waiting 2 months to see if ultimately someday, 100 years down the line, you might be ready or able to, to fight fires. The time is up, and you've got to be cleared when your time, when you have no more leave, when you have no more time off is up. You better be cleared to go back to duty. Here, it's the same line of thinking. Are we going to go back and reevaluate the employer's decision based on what they knew then? And I cannot believe that this is going to be upheld on appeal. I personally believe the court's going to say, right or wrong, 9 months later, the action is what you did then.
Well, I got to ask you a question on New York law, okay? Yeah. And I think it will help because you have this thing called an Article 78 challenge. So I want to, now, many of the lawsuits that sound like this, they look like this, are religious discrimination under Title VII of the Civil Rights Act of 64, as well as First Amendment claims under the religious discrimination 1983. So we see a lot of cases like that. This is not that. They're not alleging discrimination. Right. They're alleging that there was an Article 78. And if you can explain that so that we can distinguish, because they're just saying you made a mistake, and I'm asking you to review it under this Article 78.
Right. So in Article 78, it's literally Article 78 of the Civil Practice Law and Rules, just the court rules. And it is the colloquial, what we say, hey, we filed an Article 78 to challenge a final and binding decision of an administrative agency or a government agency or a not-for-profit agency. You just file that. And basically it says it's not asking for money normally. It's just saying they made the wrong decision. It needs to be reversed. Now, oftentimes what happens, so Article 78 is a 4-month window, statute of limitations, to file. So from the date you knew or should have known what the final agency decision was, you have 4 months to commence suit. So now that could go on forever. I have an Article 78 that's been pending now, 3 years. I'm still waiting for a decision on. But they shouldn't evaluate you based on what you know now.
No, I get that part of it. Right? I get that. I know I get that part of it. But I guess what the other cases that you referenced are religious discrimination, okay, and or constitutional violations. With an Article 78, you're just saying it's like it's like, to me, an Article 78 is like challenging the umpire's ruling. The
It is.
umpire called me out. At second base, the umpire called me out. Now I want to appeal that. And now you have a different umpire looking at the same facts and saying, no, you're safe.
Right.
Without really getting into the religious, without really getting into some of the facts here, they're just saying, on the same facts here, I find you safe.
But it always leads to money, right? If you win on the Article 78, there's always another lawsuit in court saying, hey,
Right.
law of the case, another court declared them wrong for terminating, right? Whether it violated rights is a separate issue, but it's a pretty good pretty good holding or event for a would-be plaintiff to say, hey, I just won a court where my employer was deemed wrong to be terminating me. Here, it has to be based on, let me give you a different situation, a real scenario in my office that we have where they terminate a volunteer firefighter, right, for what happened on a day. It doesn't go to trial to hearing till many, many, many months later. And at the hearing, they tried to bring in, well, let me tell you what he did 2 weeks ago. Like, wait a minute, that wasn't part of your decision. And the judge says, well, I'm going to hear it because it allows me some character, to understand his character, not for the determination, but to understand his character. I said, wait a minute, you can't do that, judge. Now the judge does it anyway, but I'm like, you can't do that because you're bringing in things that happened after the fact. Let me give the law school one that everybody knows about. A landlord owns a property and somebody trips down the stairs and alleges the light bulb was out. A day later, being cautious, the landlord goes in, changes the light bulb, puts it new light bulb in and adds more lights. The laws, every law school student knows, you can't introduce acts that happened after, right, to show, well, you fixed it, so you're liable. Otherwise, nobody would ever fix anything. So that's here, same type of thing. How do you look to what happened after? Now, let me rant about one big thing, though. Maybe this is totally irrelevant, but, Moderna and BioNTech are all doing COVID commercials right now, vaccine commercials. You know what's missing from the commercials? Warnings about their side effects. How is that possible? How is that possible that you cannot, and I'll relate this in a minute.
I'll tell you, they have immunity.
Yeah, because the government gave them immunity. There's a secret deal, and I'm not a conspiracy theorist, right? There's no way a drug company would get on TV about how safe and effective our drugs are and not mention the side effects unless the FDA somewhere said, don't worry about it. You can mislead the public and not tell them about myocarditis or any other thing. Will allow you to not do what everyone else for a freaking cold medicine has to do, right? You're gonna have diarrhea for the next 10 years of your life and you could die, right? You don't have to do that with the COVID vaccines. So it's my rant, but it's significant when I'm watching these commercials. So this judge is taking that same reaction. I agree with his reaction as a factual matter, that he's finally saying, you know what? You're wrong. We were wrong back then. We're wrong now. We thought it was effective, but it's not. Now, here's where I think factually he is wrong. What happened after the COVID vaccine came out? We got vaccinated and rates plummet. The employer wasn't necessarily wrong at the time based on what they knew. And here's what's happened. This judge is now saying what's happened since with Omicron and variants. And right now we know the vaccines don't have a long-term effect, but he's wrong back in March. In March of 2022, our rates plummeted. Factually, he's wrong. The employer was right. I don't agree with it, but they were right. So I have to step away for 1 second and I'm going to have you comment.
Yeah, and I will. And to me, I think I look at it much more narrowly. I think if this was a federal court lawsuit alleging religious discrimination or a violation of the First Amendment under religious discrimination, I think the firefighter loses. But that's not the issue in this Article 78 case. The Article 78 case is whether or not his request for a religious exemption was improperly denied. And I'm not sure of the criteria that the court uses or even FDNY uses in terms of granting or denying a religious exemption. But the bottom line is the analysis in this Article 78 case is going to be different than the analysis in a religious discrimination case. And I think that the judge may have some latitude here to take into account things that you wouldn't necessarily consider relevant if this was a religious discrimination suit in federal court. And so I don't know, it would be interesting to see, and you have your finger on the pulse of the New York court system.
Bad precedent. This is bad precedent. Well,
I certainly can't imagine FDNY is just going to sit back and they're going to appeal it. And
my bet is, I want to say here, my bet is it gets overturned.
Yeah.
Kudos to the judge. I agree with the judge, but legally he's wrong. You can't evaluate somebody on facts that didn't exist at the time, right? You can't. What he's effectively saying is you should have known what was going to happen 8 months later when the world didn't know. You can't. That's an unfair test.
Well, again, I don't think the issue here was whether or not FDNY can impose a vaccine requirement. That's not the issue. The issue here is whether or not they improperly denied a religious exemption. And if for some reason there was sufficient evidence that he should have gotten a religious exemption based on what other people had gotten or whatever, then I think it's very easy to get confused in this area. This is not a religious discrimination suit. This is an Article 78 challenging the decision to deny him an exemption. The judge saw it differently than the hearing officer, whomever made the decision in FDNY. From what I understand, there was over 1,000 requests, and there was only like 15 that were granted. That's I don't know what criteria they use in making those, but interesting issue.
It is. It's a great issue, and the basis that he ordered that on, I think, is I just disagree. But in any event, we'll see. We will certainly see. They're going to be, I believe, in the first department. What is very interesting about the first department of the 4 appellate divisions is the first department is extremely fast. I was just in front of them. They turned a case around that I was hoping would be delayed. They turned a case around in like 3 months. We were in front of them, and a month later, a decision. Is
that the one that you have the video on your website?
No, that's the state's highest court. That's the court of
appeals. You're getting grilled. Oh man, that was terrible the way they grilled you like that. That's
right. I love that.
But you know what? You kept you cool. Tip of the hat to that one, boy.
I think that, being in front of 7 very smart judges is a very difficult challenge, who have the right to tell you to shut up at any moment.
Shut up, and if you don't shut up, you're going to spend the night in jail.
Right. It's anyway, but great issues. Great. This is why we're here, and I think you'll see probably in the next 8 months you will see a decision on this, and. It's interesting. It opens up a lot. It might open up Pandora's box. Who knows? Maybe other pending decisions, Article 78 decisions are still, maybe other Article 78 challenges are still pending. And now they're looking to this to see when do we get to judge what the employer knew, now or before? And again, I think this retroactive, or you should have had the foresight to know what happens. I think this goes to all sorts of different suits. The premise of whether you can tell an employer, we're going to judge you from today, the day the court's looking at it, versus the day you made the decision. Bad idea. I'm opposed to it. Anyway, that's where we are. Great day.
Yep. We're going to wrap up here. And I do want to encourage you to please subscribe. Please click like and share for our videos. It's really important to us. We want to keep doing this. We're somewhere around 640 subscribers. We really need to get up to 1,000. We want to keep doing this. That really makes a big difference to us and our ability to keep doing this. So, please click like and share, and please subscribe. And we'll see you next week for another edition of Fire Law Roundup. Thanks, Brad. Thank you.